Hi, everyone, and thank you for joining us. Today, we are talking about whistleblowing and the challenges, but also the opportunities which this new legislation brings to companies. We are discussing this hot topic today through the prism of 4 jurisdictions where Theiss has offices. These are Bulgaria, Romania, Slovakia, and Austria. But to start with, my name is Hristina Dzhevlekova. I'm counsel with the Employment and Compliance Practice in Theiss Sofia, and I will be discussing today the new whistleblowing law in Bulgaria. Ladies, giving the floor to you.
Hi, everyone. My name is Adelina Iftime-Blagean. I'm a counsel with the Bucharest office, and I'm heading the employment team here in Romania.
Hello, my name is Schwamberger, and I'm a lawyer in the employment team at Theiss in Vienna.
Hi, my name is Zuzana Hodonova. I'm counsel in Bratislava office. I'm a regulatory specialist with focus on employment law with more than 10 years of experience in the field. So let's start with the background. Why is the whistleblowing law so important for European Union and its member states? And what is it trying to achieve?
Thank you, Zuzana. Well, I think it is fair to say that the whistleblowing legislation was probably one of the most debated pieces of law recently in the European Union. The first question was, do we need such law at all? But if you think about all these landmark cases in the recent years, like LuxLeaks, WikiLeaks, and so on, they revealed like huge tax evasions, crimes, and corruption, and that was all brought out by whistleblowers. So I guess whistleblowers are just a very effective tool. I think the issue that we are now facing is that only few of the European member states, like Germany, like France, they have whistleblowing laws and the traditions and the understanding to that. While in Central and Eastern Europe, including in Bulgaria, this is rather a novelty and we are a bit skeptical with it. Adelina, would you like to share your thoughts with us on why the implementation of the directive takes so much in different member states?
Sure. Well, to start with, for many countries in Europe, this new piece of legislation was a huge cultural change and a huge cultural challenge. Most importantly, the directive raised millions of debates and concerns, considering the multiple divergent interests around it of all main stakeholders like public authorities, private entities, NGOs, and so on. Basically, this is one of those pieces of legislation in relation to which it's basically impossible to make everyone happy. Currently, the implementation is indeed more than 1 year overdue, and still European countries are struggling. Some European countries are still struggling to implement the directive.
Yeah, I totally agree. There were many different interests of the stakeholders involved, and it was also a huge political discussion. And I think that is also why in Austria, the Whistleblowing Protection Act only entered into force very recently at the end of February 2023.
Indeed, also in Romania, the directive was finally implemented very late, only towards the end of December 2022. And this only after a very long and thorny history, which involved having multiple drafts running in parallel, challenges before the Constitutional Court, last-minute scrutiny from the European Commission in relation to the to compliance with the resilience plan for Romania, and so on.
Yeah, one of the biggest hurdles, in my opinion, also was the material scope of application, because the directive foresees that the reports shall only concern violations of EU law. And in the end, the Austrian legislator decided to go beyond the scope of application of the directive and define more general areas of law as the material scope of application. And this in Austria includes all national legal provisions in those areas, as well as EU law. And another issue that had been discussed widely in Austria is the whistleblower protection from retaliatory measures. The Austrian legislator has basically adopted the catalog of the directive, but has decided on a very strong protection. So namely the legal invalidity of such measures, as well as damages and administrative penalties. How is the situation in Slovakia, Zuzana?
In Slovakia, we had legislation dealing with protection of whistleblowers since from 2015. And in fact, Slovakia was one of the first EU countries that had adopted rules for the protection of whistleblowers. And just to say that this was not driven by EU law, but rather by specific cultural and political circumstances in Slovakia at that time. However, despite the good start, the directive is still not fully transposed, and the main reason behind that is currently unstable political situation in Slovakia, where we have cabinet without a majority in the parliament.
Great. Let's now have a look at the core of this piece of legislation, the scope of the Whistleblowing Directive, and to whom it applies.
Well, I would suggest to go one step back and touch upon the biggest question, which is probably most interesting for our audience, and it is who are the obliged parties under the Whistleblowing Directive. The short answer to that would be everyone. Each company, regardless of its size and of the industry that it that it operates in. There is this common misbelief that only companies with more than 50 employees are obliged to follow the whistleblowing law, and this is just not correct. This threshold of 50 employees, it only applies to whether you need to have internal reporting channel or not. But for all companies which do not have, member states need to assign this function to a public body. In Bulgaria, for example, this is the Commission for Personal Data Protection. So if you take it from that perspective, in fact, having an internal reporting channel is very beneficial because this allows the company to deal with the signal internally and to avoid that signal going public and leading to even more negative consequences.
Actually, Romania has since 2004 a law for whistleblowing law, which was applicable to the public system only. This law was actually a very good piece of legislation with, for instance, it covered, for instance, whistleblowers benefited from witness protection programs under that law, but the use of it was very, very limited. This new law that we have now, which implements the directive, the European directive, applies indeed to everyone, and with almost immediate effects. The only grace period that we have in our law is for entities between 50 and 249 employees, which have time to implement internal whistleblowing channels by December this year. This basically means that all other companies, including companies below 50 employees, which have certain obligations in Romania, at least the ones in the sensitive sectors, all these entities are already subject to the obligations of the directive and of the local law. And of course, this also means that all whistleblowing safeguards are already mandatory and effective.
Yeah, in Austria, we also have a grace period. So the deadline for the companies to implement the obligations under the new law is generally 6 months after the law coming into force. And for companies with less than 250 employees, the implementation must be done until mid-December this year. But one of the fundamental parts of the directive, I think, is confidentiality. Adelina, do you want to tell us something about that?
Sure. From the angle of the company's obligations under the directive, confidentiality is indeed one of the most important obligations. This covers the confidentiality of the report and, of course, of the investigation process itself. This means that companies will need to put in place to code from the GDPR appropriate technical and organizational measures to make sure that, for instance, unauthorized persons do not have access to the information, that hacking risks are minimized, that the investigations team are independent from management, and they have the authority to report when needed to external bodies, for instance, to the criminal law bodies. And similar obligations. Ladies, any specifics in your countries?
Yes, absolutely. Under new legislation in Slovakia, the confidentiality obligation covers also the identity of the person who is being reported. So the objective is to protect the privacy of the suspect while the investigation is still ongoing. In general, employers will have to treat the identity of whistleblowers as confidential, exactly as you mentioned, when receiving, verifying, and recording reports. So the identity of any whistleblower may be disclosed only with his or her previous written consent.
Well, I guess confidentiality is just one part of the question, but what is more interesting for me are the anonymous signals, because that was a huge issue in Bulgaria. We discussed it on several stages, and that was basically the reason why two of the previous draft bills were rejected by the parliament. We just don't have it in our culture and in our traditions and feel uncomfortable with anonymous whistleblowings. So currently, the law that was now adopted, it does not allow anonymous whistleblowing signals, and companies have no obligation to start investigation upon such signals. But it is also very interesting for me how this is dealt with in your countries. For example, how is it in Austria, Anna?
Yeah, on the contrary to Bulgaria, in Austria, for example, anonymous reporting is not obligatory, but it is possible. This is especially the case because some companies have had whistleblowing tools in the past before implementation of the new whistleblowing law. And some of those tools included anonymous reporting. And I think the idea was that those companies should not be obliged to change their whistleblowing tools entirely. So basically, it is up to the company whether they want to enable anonymous reporting or not.
In Romania, the situation is different from your two countries. Basically, anonymous reports are mandatory. Both companies and relevant authorities must receive and handle anonymous reports, provided that these reports contain sufficient hints of the wrongdoing. And actually, NGOs are already lobbying for amending the law from this perspective, and we already have a draft law which was already approved in the first chamber of the parliament, which eliminates the word sufficient. So now, if this draft law will be approved, this will mean that all entities will need to investigate anonymous reports based on mere hints without strong factual information or without any, at least some basic evidence. What I would like to add in relation to the anonymity concept is that, in my view, this is a primary protection mechanism, which and all the other safeguards and all the other protection mechanisms basically kick in and become applicable only later on in the process once the identity of the whistleblower is revealed.
In Slovakia, employers must investigate anonymous reports if it is reasonably clear that the report seems legitimate. And according to new law, greater protection should be provided to those who reported anonymously and whose identity was later revealed. It doesn't matter how the identity is revealed. Anonymous reporters often choose to reveal their identities during proceedings, perhaps hoping to add more weight to their report. So competent authorities handle reports where the whistleblower discloses their identity more expediently. While anonymous reporting ensures the whistleblower's protection against retaliation, it makes it more difficult to contact the whistleblower. And therefore, I believe that it would be helpful if employers introduce a technical solution allowing safe and anonymous communication with whistleblowers.
Very interesting. Another key point of any whistleblowing legislation is the obligation to properly set up the internal units and, of course, the handling of the reports. In Austria, for example, the internal unit handling the reports must be provided with the necessary financial and personnel resources to ensure that it can perform their tasks impartially unbiased, and most importantly, of course, free from any instructions. Then any report must be checked for validity, and no later than 3 months after receiving a report, the internal unit shall notify the whistleblower about what follow-up measures will be or have been taken based on the report and the following investigation. Or, of course, on the other hand, the unit will have to inform the whistleblower why the report is not being followed up, either, for example, because it did not fall into the scope of application or it did not check out as valid.
Yeah, the time limits, like in Slovakia, are quite strict. As for internal reports, Slovak law requires that the employers deal with all reports they receive. And one requirement that should be introduced with the transposition of the directive is that the employers will have to confirm the receipt of reports within 7 days. And we will have to investigate them within 9 days of receipt. Further, employees must then inform the whistleblower about the results of investigation and the adopted measures within 10 days after the investigation ends.
Yeah, what I would add in relation to the obligation to act or the obligation to follow up in the terminology of the directive is that apart from the deadlines, the directive and the local laws, at least the Romanian law, do not provide rules on how exactly to handle the investigation. For instance, whether or not it is mandatory to listen to the whistleblower or to the reported person. So basically, each company will need to design a structure for this process and will need to regulate all these aspects via internal policies.
Well, if you allow me to bump in, I think, Adelina, that this is a very important observation. And, you know, in order to close the topic and refer back to what Anna said in the beginning, it is indeed very important who would be the employees assigned with the investigation functions within the company. It appears that at the end of the day, that would be very responsible and very risky role. And in my view, this is the reason also why the directive allows that such function could be also outsourced to third companies which might be more professional into dealing with that.
Good. Let's now move to the next topic, which is the most important of all topics in relation to the whistleblowing concept, in my personal view at least, which is the safeguards. Zuzana, will you start for Slovakia?
Yes, thank you, absolutely. In my view, the most important measure for protection of whistleblower is the prohibition of retaliation. Efficient protection against retaliation is necessary for protection of public interest and freedom of speech in general, because freedom of speech promotes transparency and accountability in the society. For example, the Slovak legislation makes it possible to suspend the dismissal of employee until the employer proves to the Whistleblower Protection Office that the dismissal is not related to the whistleblower's report.
In Austria, as said before, some retaliatory measures of the company could be in fact found invalid, for example, a dismissal. And also the company might be obliged to pay damages to the whistleblower. And additionally, the Austrian law foresees something very new, that some retaliatory measures can also constitute administrative offenses. And the consequence would be that the company is subject to administrative penalties. This is quite a novelty in Austria in labor law. What protection measures are implemented in Romania, Adelina?
Well, in Romania, we have in principle all the measures and the safeguards that are regulated under the directive, including practical aspects such as the free legal advice from which the whistleblowers benefit during disciplinary processes, which are taking place presumably as a retaliation measure, and also before courts, also in relation to any follow-up actions, any actions that are resulting from a previous whistleblowing report. To me personally, it is still unclear whether or not under the directive and the Romanian law, the safeguards apply also in case of self-reporting, meaning whether the whistleblower which was involved in that specific wrongdoing that is being disclosed is protected or not. And basically, which is the primary interest protected here, whether or not the Roman law principle that a person cannot invoke his breach of the law to secure the legal protection under a legal provision takes or not precedence over the core scope of the directive, which is to have wrongdoings revealed to the benefit of the public, of the public interest.
I think that was also a very important consideration which we had in Bulgaria. You know that the concern that the whistleblower may only blow the whistle to protect himself or herself. But you know, to wrap up our discussion, at the end of the day, the benefits of the whistleblowing legislation will always outweigh the negatives. I guess my personal intake is that for companies, it is for companies to implement the proper internal policies, internal procedures, to start changing the culture within the company and so on, so they can manage this whole thing at the end of the day in their benefit. And just to mention, because you mentioned short and strict terms under your legislations, so to mention that in Bulgaria, if you're a company that needs to implement internal reporting channel, the deadline is middle of December this year, and the clock is already ticking.
Indeed, in Romania, my view is that companies are basically still confused since, as I mentioned before, the law came into effect with almost immediate effect for most of the entities covered by this law. Also, even the public authorities which are in charge with the external reporting are still setting up their operations. To me, it seems that we will de facto have a transitional period during which all relevant actors will try to determine and to understand exactly what they need to do, how to adjust, and how to prepare for for applying this law.
Yes, I think it will take some time to implement the various obligations, and also for the companies and the employees to get used to the new opportunities. And also it will be especially interesting how the courts will handle the first cases regarding protection against retaliatory measures for a justified report. But I think that this will take some time until we have the first court decisions in those cases.
In my view, the challenge for the coming period will be to monitor whether and how a culture of active reporting develops in all jurisdictions, and how the formal reporting setup will work in real life. Encouraging a culture of active reporting can happen only through education and through campaigns raising awareness.
Well, thank you very much for this interesting discussion. Hope that it was equally interesting and useful also for our audience. Theiss covers 13 jurisdictions in Central and Eastern Europe, and we constantly monitor the development of the whistleblowing legislation in each one of them. So you can check our whistleblowing tracker, which is on our website, and also follow us for more updates and useful information. Thank you very much and have a nice day. Thank you.
Thank you.
Thank you. Bye-bye.
Bye.